Great. So we're reconvening our morning session. We're able to get our legislative council to continue our walkthrough of H 687. But before we do that, I just want to talk briefly about our process for reviewing the budget, which is our committee assistant has created a very helpful budget folder available on our webpage. And our liaison for the budget, Representative Stebbins, has offered to compile, to begin a draft letter for us on our behalf over the weekend. And on Tuesday, we'll be able to review that letter and provide input to her, and hopes to getting our letter to appropriations before the Friday deadline. All right, with that, next Friday is the deadline.
Next Friday's deadline, but ideally we'll get it sooner.
Yeah. All right, with that, thanks for joining us on short notice, Ellen, and helping us take advantage of an opportunity here.
Ellen Tchaikovsky, Office of Legislative Counsel. So yesterday we left off on page 57. But I don't know what you wanted to do right now.
Well, we actually had asked, and I don't know if you've had a chance about, or maybe we covered the source of the appeals language. Asked about where it came from. I think we covered that. So
I don't know specific. I can't remember specifically.
the 20 persons, we were talking about that. And then I think I asked if we could understand where it came from. And then you read us the language from how municipal appeals happen today. So I think we should move on to section 26.
So at the bottom of page 57, section 26, planned growth area guidelines. So on or before January 1, 2026, the ERB shall publish guidelines to direct municipalities seeking to obtain the planned growth area designation. So in the prior draft, this was 2027. The planners have asked to move it up. That's why to 2026.
So we have, I guess this for me just makes me want a timeline, which I hope you're working on a time, or, for the bill.
Yeah, and I just want to be careful when I draft it to make sure that I'm not mid-draft when you're making changes. So I'm assuming you're going to want to see a new draft next week, potentially.
Depends on how far we get. We're not
Okay.
through this draft. And I think, but it's a chicken and egg thing, and we need a timeline so that we can make sure that as we're making changes that we keep things lined up. So they will change, but having the things that are time related on a list so that will be really helpful.
Sure. Can you give me a specific deadline?
Tuesday?
Okay.
Thank you.
Page 57, and I think I must have missed some committee time, some questions, which I'll go back on at this point. But on page 57, on line 8, I had a question around in C, the regional planning commission for the region includes a designated area or a regional planning commission whose region adjoins the municipality in which the designated area is located. And a question that I had is, could we potentially have 2 regional planning commissions, like on a border property here?
I don't know.
What would this language allow for that?
But I think you're asking more of a geography question about how the boundaries are drawn. And so off the top of my head, I don't know if there is I guess potentially if the boundaries line up that way.
So this is, right. Okay, so this is a planned growth area. So if there's a planned growth area in a community that's being reviewed, an interested person who can appeal includes an RPC that covers that area or is joining, could you potentially have two RPCs appeal?
So I think yes, but I don't know if the geography lines up that way. So maybe
But it's, I mean, it
Yeah.
could, if it's a town that's on the border.
Yeah.
it'd have to be like a corner.
To be adjacent to.
And so are there any other examples where that happens now with RPC engagement? Just to understand if this might be a problem or how we might.
I believe it does, but we need to confirm that with the regional planners, how it happens now with their processes that are in towns that are in different regional planning commission districts, but touching each other.
Great, thank you. And then on section 26, I know the chair's asked for a timeline. That rolling back a timeline seems very ambitious to me, but I guess we have to consider that.
So moving on to page 58, section 27 is amending 4382, which is the municipal plan section. And there isn't any change in this section, but I did just want to point out for big picture questions, all that's being done on page 58 and 4382 is requiring that the municipal plan add the planned growth area to their maps. We haven't talked about this in a while. If there's anything else you want them specifically to be adding to their maps. Currently, you do require in the statute that anytime a municipality is interested in getting another designation, they put it on their maps. So just a thought, but otherwise, right now, it's just adding that they have to add the planned growth area to their map if they're going to seek a designation for it. So, section 28.
Just 6033, remind me is which?
The planned growth area designation.
Logan?
Thank you. Do we need to change the reference to chapter 76A? Wasn't that?
So I gave myself, there's revision authority at the end of the bill. I can do it here. I'm gonna have to go through and change many of them. Yeah.
Okay. But I'm correct in thinking that every time we see chapter 76A, it's referring to it will be referring to a new chapter, right?
Yeah, although I do think there's still lingering question of if you want to go with a new chapter or if you want to partially repeal and then backfill 76A with the new designation program. So section 28 is the exemptions associated with the new tier 1 program. So there is a proposed change on page 59. I'll read through the whole section. So these are Act 250 exemptions. So notwithstanding any other provision of this chapter to the contrary, no permit or permit amendment is required for any subdivision, development, or change to an existing project that is located entirely within a tier 1A planned growth area designated under section 6033. So that's a full exemption for tier 1A. Notwithstanding any other provision of this chapter to the contrary, no permit or permit amendment is required for 50 units or fewer of housing on 10 acres or less located entirely within a tier 1B area approved by the board under section 6033 and 4348. So the language that's highlighted there was proposed again by the planners. And then the rest of this section talks about the permits that have been previously issued. So upon receiving notice and a copy of the permit issued by the appropriate municipal panel under 4460F, a previously issued permit for a development or subdivision located in a planned growth area shall remain attached to the property. However, neither the board nor the Agency of Natural Resources shall enforce the permit or assert amendment jurisdiction on the tract or tracts of land unless the designation is revoked or the municipality has not taken any action to enforce the conditions of the permit.
Representative Sibilia, then Sadkowitz.
So this may seem foundational, and I apologize, but we are talking about here a full exemption for Tier 1A. That would be housing or commercial or industrial. Is industrial possible in a planned growth area?
Actually.
Okay, so full exemption. That, and then for a tier 1B, it is only for housing.
Yeah.
And it's only 50 units of housing or less.
Yes.
And tier 1B is water or sewer, is that right?
Representative Sadkowitz, then Stebbins.
I just want to make sure that I'm clear on the intent behind the 10 acres or less, 50 units or fewer of housing in 1B. And I'm guessing that's to make it so that a developer couldn't spread out 50 units on a really large parcel.
Exactly.
Okay.
Which presumably the boundaries of the 1B would be limit that anyway, but I think it's also sort of a recognition of the consistency with 1 acre, 10 acre and existing jurisdictional triggers. Representative Stebbins.
Thanks, Madam Chair. I guess I didn't quite capture the difference in what the 1A versus 1B exemption allows a community to do until Rep. Sibilia asked. So 1B is only for housing effectively. And I mean, that's sort of a policy question, like, is that, I mean, maybe is that an arbitrary choice? I mean, if a community 1B has said, this is where we want to grow and we meet the municipal plan, the zoning and subdivision bylaws, we have water or sewer, and then the whole river stuff that we talked about yesterday. Is there a reason why they would not be allowed to have a small coffee shop or?
A small coffee shop likely would not trigger Act 250. And I think you always have to go back to what are the existing jurisdictional triggers and what would be captured by them, right? So I don't know when a small coffee shop would trigger Act 250. But all we're talking about is Act 250 jurisdiction.
Okay.
Did you have something? Representative Morris.
Thank you, Madam.
I just listening to Gus this morning, and I'm just wondering, specific to primary ag soils, and I don't know how many towns would have this in a 1A, 1B potentially. These could be built on primary ag soils without mitigation. I just wanted to.
Yeah, connect the dots, good.
Yep.
Mhm.
This is tier 1A and B?
Yeah, they both could be. That's what we took testimony on this morning. The impacts of the mitigation fees, loss of mitigation fees,
Loss of mitigation. Period.
and loss of mitigation, right? Excuse me.
I have an unrelated issue to flag that hasn't come up in this committee yet, but has come up elsewhere. Priority housing projects.
Yes, it did come up earlier, but go ahead, because Representative Logan's been tracking some conversations that are happening on the impacts of priority housing projects and suggested we hear from folks, but we'd love to hear from you as well.
Sure, so currently under Act 250, there is this concept of priority housing project. They are defined as affordable housing projects located within designated areas. And there's a cap on the number of units, but those projects are then exempt from Act 250. If you create a full exemption for planned growth areas, depending on how the definition shakes out on planned growth area, that may fully sort of subsume what are what are priority housing projects. It's still a little unclear to me exactly if existing designations line up specifically with planned growth areas. I don't think we have, there is language now that the municipality needs to actively apply for the planned growth area. So perhaps all the ones that have existing downtowns, maybe they won't get a planned growth area. But also maybe they will. And so then the question is, that won't necessarily negatively impact existing priority housing projects, but if you probably would want to repeal that concept because there wouldn't necessarily be a use for it.
Which concept?
Priority housing project.
Except for if a town chooses not to become a 1A and they want to stay kind of the way they are, right? I mean.
Well, so then that leads to Tier 1B. So Tier 1B is the designation process is through the Regional Planning Commission and the municipality. And so I'm not sure how you're envisioning that. It seems more like more automatic than the planned growth area designation. And so those are 50, that's 50 units, as we just mentioned, and the smallest cap for priority housing project is 50 units also.
Okay. Actually good to know. And we are imagining that the towns need to it'll be easier to get a 1B, but the town needs to want it. So that they would need to indicate, yes, we want in on that. And I hear you, but also I think important to remember that we suspended the cap on that for 3 years last year.
Yes. There's that too. So that does sunset. And so depending on how you decide to handle that sunset, but yeah, so then moving forward, priority housing projects would be available in a very limited subset of towns. So you may want to just consider that.
Yeah, we are. Chair Haskell, did you want to say something? You look, oh, okay. Representative Logan.
Yeah, thank you. Actually, that's my question. Where would they actually apply? And seems to me that they would not apply anywhere anymore. The 1B, including basically every other designation. Areas that have any, designation where a priority housing project would have.
So currently, you can have a priority housing project in a downtown, a new town center, growth center, or neighborhood development area. And so we know that there are 23 downtowns and 3 new town centers, so that's 26 towns. And then a growth center and NDA have to correlate to one of those core. So I think it's somewhere in the realm of 26 towns currently have the ability to use the priority housing project designation. And then those designations that are all the ones with the most, the more stringent requirements. And so your Tier 1A does have additional requirements beyond what's currently already required for a designated area. There is overlap in some of them, but not full overlap. So existing designated downtowns under this bill wouldn't necessarily automatically get the Tier 1A. So I guess the question is how many of those existing towns either currently don't qualify and won't seek to qualify for tier 1A, or how long it's going to take them to get into compliance to get tier 1A.
Well, I guess my question is, even for tier 1B, since we're giving, Act 250 exemption for up to 50 units of housing. And it includes downtowns, village centers. I'm not sure why the planned growth areas is in this list on page 49, actually. That's a little confusing.
It's because of the planner's definitions for the planned, for the future land use maps.
Which is why you started using the term base growth area.
Yes.
Okay, all right, and village areas, so downtowns, village centers. Planned growth areas and village areas will all. As downtown, and village centers and neighborhood areas, so all be referred to as tier 1B as part of the
If those
designation process.
Those are the map categories. Those
Right.
are not state designation categories.
Right, I know, but they would all be tier 1B. So even if they had the state designation, they would still all be, they would be tier 1B. I just don't see how there will be any area that where, yeah. I mean, I agree with you. I'm saying that if we're gonna do this, then we should probably repeal the concept of a priority housing project, but then we should try to figure out what to replace it with. To continue to incentivize the development of affordable housing.
Yes. That's what
That's what I'm trying
You're
to-
gonna solve over the weekend.
Well, yeah. Like solve in the form of, like, we need another year to figure out what we need to do is actually what's gonna happen, so. From the conversations I've had so far, like finding a framework that works for the smallest town to the largest planned growth area. Is something that we can't do on the timeline that we have this year.
Representative Sibilia.
So this conversation is bringing me to another challenge that I'm having, which is understanding the kind of current state versus proposed future state around the designations. I find that to be really adding a lot of complexity to something that is a pretty big change and already complex. So I'm just looking for some help on that, maybe not in this moment. I'm figuring that out.
Representative Subcommittee.
I hear and really appreciate the concerns around property housing projects. I'm worried that, my question really, not really worried. My question is, do we have like real evidence to think that this, because we're basically what we're doing is we're not making it any harder for these types of projects to happen. We're just leveling the playing field, sort of. So in practice, will that actually create, market forces or other forces that will make it harder through some sort of competition for space, maybe, or something like that, for these kinds of projects to happen? And I guess it's not really clear, right, that's the case. I don't know enough about the dynamics of that whole.
Well, we did hear testimony early on that there was not a concern that we were doing this. And so I think I'll be curious to hear the evolution in the thinking about why now there's a concern, even though we brought it up earlier and we were told there wasn't a concern. So I guess stay tuned and we'll hear more. Right.
Okay. So section 29 then lays out what the municipality has to do in their, they have to bring the Act 250 permit conditions over to the municipal permits. And then on page 61,
I just want to note, like, I have really done my best to kind of go from 2.1 to 3.1 to 4.1 and kind of carry forward the changes. And I have found some places where they're not, so I'm kind of reserving the right to say, I'm doing my best to go through this as quickly as possible. If I don't have a question, it doesn't mean I mean, I may have a question on from Rubia.
so on page 61, there's an added reference to tier 1B. So this is still on the municipal permit section. So within a designated tier 1A planned growth area or tier 1B base growth area, the appropriate municipal panel shall enforce any existing permits issued under under Act 250. And someone did point out last week that this language is a little confusing. I think it should probably be permit conditions.
Makes sense. Representative Celia.
So, so do we take testimony from any municipalities or VLCT about the ability of 1As to do, or 1B areas to do this, to enforce? Like, how do we know they'll be able to enforce these conditions?
Well, I think that's part of why we are requiring them to have adequate staff, and these are towns that already have permits and enforce them of the municipal permits. Did you have something else to add?
No, yeah, and so that's why just saying permit on this sentence is confusing, because the language above this is saying they bring the Act 250 permit conditions into their permits and would enforce them as they would the permits they already issue.
Representative Clifford.
Sure. So I'm a little confused. And so you said they would bring the Act 250 permits into their municipal permitting process, correct?
The conditions, yes.
Oh, the conditions.
Yeah.
Okay, so they're not.
Yeah, so this is an interesting, I mean, I can go back and read through the language for you, but they have these two permits.
Right.
An Act 250 and a municipality. And so Act 250 jurisdiction over the project is going away. And so the question is, what do you do with that permit and the conditions that were installed in it when it was first agreed to? And so that may include hours of operation and noise limits. And so now that the municipality is going to have sole jurisdiction overseeing this, they have to pull in the conditions into their permit so that then they can enforce those established conditions.
So how are they actually exempt if they still have to do the same process of an Act 250 permit?
So they don't have to do the same
Process?
process. Yeah, they're not going through that process. So it's eliminating, the fees and the appeals and the Act 250 process itself. But for some of these existing things that years ago went through the process and had conditions established, the neighbors of that and the parties to that case originally rely on those conditions. And so the municipality is being given the task of taking over enforcement of them because Act 250 jurisdiction is going away. And they have the ability to get rid of any that are no longer relevant. But some of those were existing conditions were heavily negotiated as part of a process. And so the question is, just because Act 250 jurisdiction is going away, should all of that work on the original permit go away also? But this is giving the municipality direction to enforce those conditions under its enforcement authority.
So I guess what you'd be actually, it'd be time you'd be saving rather than going through, the process with the state. You would actually save the time. Is that basically what it is? I mean, because you're dealing with it yourself and not waiting on a decision to come back, it could be quicker.
Yeah, I think there's a few different dimensions: time, money, lack of appeals on the Act 250 side.
Okay.
But Representative Clifford, this is specifically just existing Act 250 permits, how to continue what to do with them. Representative
And
Bongard.
I was only gonna say that the alternative would be leave active 50 jurisdiction over enforcement. And then you're kind of mixing apples and oranges, and what we're trying to do is just make the clean. That's just if you, to get the clean break, then you have to take over the responsibility for those conditions. So it's really trying to save the community, you're in charge. But since those were, neighbors relied on them, let's say at the time the permit was issued, that they have to be either amended, the town can amend them too. If that's what's called for, or force them, without having to get Act 250 only partway out. It's to get it out and put the communities in charge. That's the concept of it.
Because my concern is still about whether or not a municipality would have the staffing, especially the smaller towns, you know, I mean, I can see the bigger cities might be able to swing it.
Yeah,
Benefit, I think, would outweigh, you know, what you're dealing with, even if they had to do like a part-time person or something like that, if the benefit would outweigh that. Thank you.
I was gonna say the same thing. I mean, depending on the community, trying to get to that clean demarcation makes sense to me, except, you know, where are some of our, you know, ski resorts, right? They're not necessarily all in communities that have, towns that have capacity. So that's the part where I think, I mean, those are not tiny. You know, if a ski resort is looking to modify, I don't know, I'm making stuff up.
So time out just for a second. I don't think a ski resort's gonna be in a planned growth area.
Right, sorry, I am talking more about 1B. If you have a community and you're giving an existing like 40-year-old Act 250 or whatever, 25-year-old Act 250 permit to a town without capacity, that's more what I'm referring to.
Representative Bongard.
Except just to play this out, I'm thinking about Bromley in Peru. Little Peru, Bromley's in Peru. Peru, if it had to award, which it doesn't, but assume for the sake of the question, it could be a 1B. Bromley would be outside of the 1B area, so it wouldn't change anything. So you're likely not gonna have your ski area in the, in fact, by definition, almost you're not gonna be in the area where the exemption takes place.
Thanks for spelling that out.
Yeah, but I know those two there.
It just, if I may,
Representative.
it's just thought, and to follow up on Representative Bongard's statement. The 1A, 1B areas are very small. They've got to have the adequate staff in order to do the permitting,
That's the way it's written now.
the way it's written. So we're not talking about tier 3s or outside those areas. It's a very small. Remember the map on the 1A, B wasn't expansive through the state. If I have it correct.
On that point, I don't know if currently there is a specification of a size limit on tier 1B. So, it does say that there are portions of the maps that include the downtown's village center, planned growth areas and village areas. So it doesn't necessarily have a size directly associated with that. I'm just
What
trying to.
page are you on?
I'm on, that's on page 49. And so I'm just trying to picture if those categories are inherently sort of size limited because they are sort of indicative of cores. But I just want to flag that.
Yeah, and I think there's, yeah, we need to figure out where to clarify that. And I would ask you to help us find that place.
Okay.
And is it back in this area? Probably. Yeah. Representative Bell.
Okay.
Representative.
Another question, actually, to get my head around the conditions question, I wonder if it's a question for the NRB, if we might just, what does, right now, what, can you give an example of enforcing a condition, like who, like how would enforcement come to light and who would do it? Like what would happen? Just so we have a sense of how, what.
Good question. We have Peter Gill here with us who could speak to how that happens today.
Right, Pete Gill, Executive Director for the Natural Resources Board. So enforcement, we have 2 enforcement compliance officers. And we have 2 attorneys that help on the enforcement team and 1 legal technician. We have a complaint system that is on our website. Individuals can lodge a complaint electronically. It goes into the inbox for the legal team, and they can review that and determine whether there's a violation. There's a number of different mechanisms that are in the statute that allow us to follow through with those. If it's determined that there is potential for a violation, the starting point is with a notice of alleged violation, the NOAV. That's then filed or issued or mailed to the respondent, the one that the complaint is lodged against. There's oftentimes site visits that go along with that to fact check and verify. And then the next step usually, so we would get a response from the individual on that notice of alleged violation. They have an opportunity to say their side of the story. Again, there's oftentimes a site visit to confirm things. And then they can, they have an opportunity to voluntarily comply. Generally, the notice of alleged violation will also include compliance directives. So they may say, we understand you don't have a permit, please apply for a permit. And the individual will have that opportunity to then apply for a permit. If that voluntary compliance is not achieved, then there are other mechanisms in the statute. So an AOD is a negotiated settlement agreement that oftentimes will include a penalty amount. I should have said before that notice of alleged violations do not include penalty amounts. The AOD oftentimes will include a penalty or some sort of along with other directives. And then kind of pulling out all of the stops would be a administrative order, and that would require somebody to do certain actions and certain payments, and those can be then appealed at the environmental court. It's kind of broad blush, but I'm happy to get back on any of that.
Give us a sense of how many of these you have to deal with in a year.
Yeah, I can pull up our annual report and get the exact numbers. I know we filed it with this committee. I don't have it up on the top of my head right now, but
Yeah, okay. Should have homework as a committee to read that. Representative Sibilia.
Just, I guess a broader question then, given this, I don't understand how that translates to existing municipal permit enforcement.
so that does not occur currently. We don't have that authority under the statute to enforce on municipal permits.
No, I think I'm asking about current municipal permit enforcement, current Act 250 enforcement, conditions enforcement. And so if we're proposing to move that over, and why are we proposing to move that over to municipalities?
Well, there's a pretty strong interest to have these growth areas exempt from Act 250 and well, as Representative Bongart's mentioned, if we do that, then having one permit authority in those areas be the town makes it more straightforward for those folks with those permits. That's the intent of it.
So,
Right, so a question, there's like an inherent question of if Act 250 no longer has jurisdiction in those areas, what happens to an existing Act 250 permit? So this is one way to handle that, is to have the permit conditions go into a municipal permit. So a municipal,
conditions go into,
municipal,
that's what we're saying here, is we're gonna take the conditions and put them into so
municipal,
you're gonna have to convert a Act 250 into a municipal permit.
the Act 250 permit conditions.
Yeah.
And so municipalities currently have the authority to attach conditions to Act 250. And I think in prior sessions you have heard, or municipality has authority to attach conditions to the permits they issue. And I think in prior sessions you have heard in some cases, there's overlap between what the permit conditions are if as is in most cases, there's a municipal permit and an Act 250 permit in a situation. And so there's often overlap because they look at similar issues. They don't look at all of the same issues. They look at very similar issues currently. And so often there is similar conditions that are attached because they're mitigating the same issue that comes up. And so this is trying to address the situation where if there are conditions that are going to be lost from the Act 250 permit that are still relevant to the existing situation on the site, they should be carried over into the municipal permit.
Do we have a process outlined in this bill for when you seek your 1A or 1B? How the 250 conditions, like, okay, so now you're a 1A, and here's now what is going to happen with the 250, we do have that.
Yeah, yep, that's the page we're on.
Wow, okay.
So it's page 59, page 60 and 61 is the language.
This is actually telling us.
Yeah.
How to move the 250 conditions over to.
And it gives the municipality the ability to delete or not transfer over ones that are no longer relevant to the site.
The municipality gets to make that determination?
Yes. And there's criteria here on this page.
Okay.
For what that involves.
Great.
Madam Chair, I've got the report pulled up, but I could give you those numbers really quick if you'd like, if it would be helpful. So for calendar year 2023, we had 136 new investigations that were opened, as compared to 2022 was 103. Formal enforcement actions that were initiated or ongoing is 50, as compared to 41 last year. 13 violations were resolved through formal enforcement, as compared to 11 last year. Violations and complaints resolved without formal enforcement was 102 this year, and 66 the previous year. Penalties assessed was 43,000 this year, 64,000 last year. Penalties collected, roughly all of them, 43,000 again for this year and 72,000 for the previous year. So we collected some that came in the year before or were assessed the year before, I think. And enforcement cost assessed. So we also are allowed to assess the costs that are from our enforcement officers, et cetera. 3,800 this last year and 11,200 the previous year. We go back to 2019 and report. It's on page 13 of 14. One last thing I'll mention is we also have the ability to issue citations, which is sort of like a administrative order, but the penalty amounts are much less than the latitude that we have with the administrative order.
Did you add a second officer last year or hire a second officer last year?
Yes, we have two now.
Mhm.
When that happened, it was before I came on in November of last year, so I don't have the full history of that, but it's relatively recent.
And if Clifford?
Thank you, Madam Chair. Yeah, there's section 29 that we're on at page 60.
Mhm.
Appropriate municipal panel, can that be, does it have to be tied to the, like, if you have a zoning department, or can that also be their local planning commission? Can they be part of the municipal panel?
Depends. So that's the generic phrase in Title 24 on how the municipality has structured their development review. And so it's a generic term that could involve the planning commission, but it's the DRB or the Board of Adjustment. And it doesn't, so towns have it structured differently. So whoever is the panel that does the development review and issues the permit.
Okay,
So in many towns, it isn't the planning commission,
right.
but depending on how they structure it,
It would be local, if you have local DRB.
yeah.
Because we're all. Thanks, thank you.
You have something else, Representative Sibilia?
Yeah. So I have two questions, actually. One is for Mr. Gill regarding the enforcement data that you just provided. Side question. Is there any penalty for frivolous or unfounded complaints? Like who pays for your work on that?
No, there's not. What you're asking is whether a complainant has any liability if there is no violation found. Is that?
Yeah.
There isn't any.
Disincentive there. And then my other question is around just the overall benefit to Vermonters, Vermont communities in moving this enforcement to communities. Is there a benefit to the communities in kind of doing this? What are the benefits?
In some ways, it's up for the community to decide when they're considering whether they want to apply to be a planned growth area and have this exemption. So find out if you think there's going to be a benefit.
So I wonder about making this optional enforcement.
So I think there's kind of two things in what you just said. So obviously, anytime any body has enforcement, they have enforcement discretion. And so they have the ability to determine at what level they seek to enforce something. That is an issue that does come up sometimes, and it is addressed in here in that if the municipality fails to ever enforce something, Act 250 enforcement jurisdiction kicks back in. So that's why they have to have adequate municipal staff to be enforcing their permits. Hopefully they already do if they already have a functioning development review process. But I will say the part of what is happening here is that these are existing Act 250 permits that could have been in existence for a long time that reflect often negotiated agreements with the original parties to the permit. And so I think traffic and noise are like, and hours of operation are kind of, and lighting are some of these things that could be captured there, where if the condition went away, it could have a detrimental effect on the community because that condition would go away. And so if there was a condition that the bright spotlights on your building had to be turned off by 10 p.m. every night, and that condition went away because the Act 250 permit no longer existed, then that could be a detriment to anyone in the community who had been relying on the fact that there weren't bright lights being shown every night.
So what's the benefit? So if we're carrying over the conditions, and something just clicked for me here, which is, we're literally getting rid of the Act 250 permit. We're just keeping the conditions, I guess, right?
So this bill is suspending it frozen in time, essentially. But it is, yes, carrying it over to the carrying the permit conditions from the Act 250 permit into the municipal permit.
So what if we didn't do that? What if we just left enforcement of these Act 250 permits to the NRB? And just like suspended going forward, like it's just exempt going forward. I mean, so what's the benefit of exemption on existing permits?
So that's what I was explaining, that then there would be no enforcement on potentially detrimental issues to the community. So there's the possibility that there are issues addressed in the Act 250 permit that are not in the municipal permit.
I think what Representative Sibilia is asking is why not just keep the NRB enforcing these permits? It's just a choice for us right now.
Oh, yeah, I mean, if you wanted to go that route, I think you could.
Yeah, I just don't understand the benefit of exemption on existing permit holders.
So it could lead to some confusion. Because if there's an existing Act 250 permit, but then you are overlaying this exemption on top of it, that means they don't need to make any updates to the Act 250 permit. And so they could make changes to the site, and then the permit would no longer reflect it. So how could the Act 250 office enforce against something that no longer matches the site on the ground?
Thank you. This just is an open area for me in terms of existing permits.
The next section makes a couple of small updates to the goals of chapter 117. There are no changes in this section. Section 30.
Oh no, we were on 61? Yes.
Yes, 61.
Oh, I wrote those down, sorry. Um. Oh, on 62 under A. If I may.
Yes.
Just kind of coming back again. What are we doing here? Future land use maps. So the insertion here of downtowns, village centers, planned growth areas and village areas. Again, feeling complexity here.
So these are the goals for municipalities and regional planning commissions as they adopt their plans. And so this is an encouragement that intense residential development be located in those areas. I don't think you actually need to make this change if you don't want to, but this is again some synchronicity between the new terms that are being added to the regional maps so that they line up. So these terms that are underlined are part of the future land use maps and the regional plans, and those are the categories that are being proposed. So it's adding the reference to them as opposed to community centers. So I don't think it's changing the substance really. Community center is just not a defined term. And so I don't think if you didn't want to make this change, I don't think it would be an issue, but I think it's trying to connect it back to the new terms for the maps.
Representative Sacramento.
Question that this explanation just brought up for me, which is that these are all couched in the language of shoulds, and so they're not really directive, they're more suggestive as aspirational more than anything else. Okay. That sort of is a little bit connected to my other question on this page, which was about on line 5 on page 62, which says that they should be planned to accommodate the majority of housing needed to reach housing targets. And I was just thinking about that in terms of that still leaves a lot of housing potentially, depending upon how the areas develop their plans to be planned for outside these areas, and whether we should be, especially since it's just a suggestion, maybe suggesting like something more, a little stronger than just 51% of them.
Other thoughts on that suggestion? Do you have a suggestion for something stronger rather than?
I was trying to come up with a term that wasn't perhaps too strong, like vast majority.
Yeah.
Something along those lines.
So I think I put that out there as something to think about, and if you come up with something you want to propose,
Sure.
bring that back.
So the next changes are on page 66 and 67. And this is in the section on the duties of the regional planning commissions.
Sebelia.
Yeah, just a question on existing statute on page 65. Line 18. And this is duties of the regional planning commission. So conducting capacity studies is what?
I don't know.
It's of interest to me because there's such stress on our existing capacity.
Yeah, it strikes me as a term of art, and so I don't really know what is encompassed in that. So there are changes highlighted at the bottom of page 66 and into 67. These are from the planners, and they're based on the conversation you all had last week about what they had proposed last week. So it's striking reference to them first at the bottom of page 66, participating in municipal regulatory proceedings. So to some extent, they have that option already. This was requiring them to participate in the municipal regulatory proceedings. So that is a proposal from them. And then related at the top of 67, review and participate as an interested party in the municipal development review process for projects as defined having a substantial regional impact. So that's also being struck. And so they had proposed that in the last draft, that they would seek to participate more. Now they're walking that back.
You tell me how existing substantial regional impact is.
No, I really don't really know much about this concept. It is an existing concept in regional plans. They are supposed to define for each region what a substantial regional impact is. But I'm not really familiar much with that process.
Did we take did the RPCs testify about how that's developed? The assessment around substantial. Imagine it's commission members. Did we take testimony?
I am not sure if we took testimony beyond it, being brought as a suggestion.
Okay.
This is existing language, right?
66.
Number 17.
Number 17 is yes. So that is existing. I just don't really know much about how it functions. Yeah.
But it's just given regional planning commissions the option to become participants or not.
Right, but she's also asking about substantial regional impact, and I don't know how that currently works.
Other than the fact that it's existing.
Yeah.
We're giving substantial regional, we're changing the consideration of it from due consideration to substantial deference, right? What's the difference in that?
due consideration and substantial deference, I think Ellen can,
Yeah, it's significantly stronger. Substantial deference is significantly stronger.
So that's not existing.
Right, it's setting a higher strength for that determination.
we'll ask these questions when we get the RBCs back in here. And it's actually, yeah. Good. Anything else on this one? I guess with that, it's about noon, so I think break and we'll be back at 1. Additional testimony and then